Hello, everyone. My name is Apar Gupta. We are trying out StreamYard today. So there have been some glitches for the ones who are tuning in live. And I hope my audio and video is coming to you clearly. We are trying to present a quarter of work from April to June. This is the second quarterly members call. And I'll be introducing you to the work which we have done, but also more importantly, to all my colleagues who have done this work, which has resulted in incredible amounts of impact. And just to give you a brief idea about this call, I'll come to the second slide. If we can have the second slide now. So we are going to go through three verticals of work. And firstly, we'll be dealing with the litigation and policy work. And then we'll be coming a little bit to the civic literacy and media advocacy, which IFF is very well known for. And finally, we'll be touching upon the fundraising which has happened, the money which has been coming in, and how have we been using the kind of financial security that provides us to conduct this work on a month to month and a quarter to quarter basis. So, firstly, just the quarter at a glance at the third slide. If we can have the third slide now. So basically, we were having a very heavy court calendar because there was such a rise in the amount of account suspensions and censorship which has been occurring very widely across social media platforms, which has impacted journalists, which has impacted creators. Quite often, people who are critical of government policies. And my colleagues will be going into that. And we also were filing or co-signing policy submissions, letters, and explainers on the IT rules, which have already been amended once this year and were further then put to a process of amendment, which were the second amendments to the IT rules, further expanding those censorial powers. There were some state hate speech laws, and there was also some platform overreach. And a lot of this was also into a civic advocacy mode in which we attempted to enable people to send email submissions to the Ministry of Electronics and IT on the public consultation, and it then was able to inspire, I hope, about 5,000 to 6,000 people to send these comments. So it actually had that. We also then started a month our annual membership drive. And in the annual membership drive, we were able to raise about 76 lakhs. I think that's the total amount of money which was there in our account, but I think so about 58 lakhs. And we welcomed additional 296 members, which has now unfortunately dropped to 250. And the total number then reached to uh, touched about 500 members. So I know these figures are a little confusing, but a clearer statement of that is provided every month by us in our tweets. So we have also started making granular financial disclosures, and the submissions, which as we earlier stated, were made to mighty three state governments, Meta's oversight board. And also filings in the Delhi High Court. So this quarter reflects both the breadth of the threats to our digital rights as well as IFF's response, which has built in capacity. And the first vertical which I want to go through is strategic litigation, for which let's have slide number 4, in which the courts remained a very critical institution in which we were able to resist overbroad government censorship. And I'll hand this over to my colleagues who will be taking you through this. This includes Indu Mugi, Avanti, and Naman. So I'm turning it over to them where they can explain you both what we did strategically in terms of a one litigation which helps enable set a doctrine or a precedent which helps a lot of people, or an individual case in which we are able to offer clinical support. So over to you, I think, Naman.
So, firstly, I will start with the issues with the blocking issues we have faced. So, in the last quarter, I did talk about right to be forgotten. Now, I think we have moved on to more of a blocking issues, litigation issues we have faced. Uh, I would like to famously quote one of the arguing counsel in those matters when she described these. So there were 12 accounts were blocked by the government of India, which were critical about the government. I hope I am visible now. So, which were pretty critical about the government, and they were famously known as the dirty dozens. I remember hearing it in the hearing. So, first, I will talk about the blockings under Section 69A. Then, my colleague Avanti will take over and explain the 79(3)(b) blockings. Firstly, Section 69A blocking is constitutionally scrutinized where important safeguards are available, such as in blocking rules of 2009. There is a pre-hearing rule and then a post-hearing, decisional hearing provisions are also available. Similarly, in intermediary rules as well, there are pre-decisional and post-decisional hearing provisions are available. But what we have seen in recent blocking issues is that the activist or a journalist is not getting any blocking order or anything before their account is getting blocked. What we have noticed that first they are getting their accounts blocked, then they are pursuing the litigation to even get the blocking order. Uh, as we have already pursued one litigation, if you remember, Tanul Thakur versus Union of India, where the Delhi High Court rightly pointed out that if your account is getting blocked as a safeguard method, you must receive a blocking order in order to know why your account is getting blocked, which we have noticed here the mighty is totally rejecting it. Similarly, uh, Vikram, could you please move to the second slide? Thank you. So, in this particular cases where we have handled the blocking, Mighty withheld X accounts which are critical to the ruling party, and we have provided pro bono legal support to them. There were, for example, they were not getting the IMC hearing, interministerial committee meeting hearing before the blocking of their accounts. So we moved before the Delhi High Court, and Delhi High Court rightly ordered Mighty to take the interministerial committee meeting and then give the final blocking order. And we have also pointed out to the court that how it's not proportional. Their whole account is getting blocked, whereas it should not be like this. They should be proportional, and if they are only issues with only specific posts, they should only block them. Whereas we have noticed a pattern in these blockings where uh, the blocking of the whole account is the norm. They were not blocking the specific posts which are uh, they found against the government or violation of Article 19.2. Similarly, uh, through this litigation, activists and satirists, their account was unblocked, and ultimately, we still yet to receive the blocking orders there, but they still did not give us the blocking order. And we have filed a contempt petition against in one of those petitions, and they are still pending before the Honorable Delhi High Court. And we will update in the next quarter how it goes on. Over to you, Avanti.
Thank you, Naman. I will now be talking about the other way in which blocking of social media posts and accounts is being carried out by both the central as well as various state governments, which is through a provision called the Section 79(3)(b) under the Information and Technology Act of 2000, and how IFF has helped people whose accounts have been blocked under this provision. So, firstly, a very quick explanation about what Section 79(3)(b) is. It's basically a provision under the IT Act which carves carves out an exception to the quote unquote safe harbor, which is granted to online intermediaries. And safe harbor is what protects intermediaries from incurring any liability for third party content that is uploaded on their platform. So, while blockings are usually supposed to be carried out under Section 69E, which Naman discussed, over the past, over the recent past, what has happened is that the Ministry of Home Affairs has developed and is now operating a portal called the Sahyog portal, which is a centralized portal which automates the process of sending takedown notices to online intermediaries whenever any content or account is found to be posting allegedly objectionable and unlawful content. And in the past 3 months, IFF has provided pro bono legal representation to four individuals who have either had their content or their entire account on social media platforms such as X, Instagram, Facebook blocked in India via notices issued through the Sahyog portal. So these four internet users, or like social media users rather, which are Molitics Infomedia Private Limited, which is a digital news publisher, an individual known as Saral Patel, who is a national media panelist of a major political party, Mr. Deepak Kumar, who is an independent digital content creator, and Rafiq Mohammed, who is a stand-up comedian, had their social media accounts restricted in India. They received identically worded notifications which cited Section 79(3)(b) from the respective social media platform as the reason for their account being withheld. And there are several issues when you receive a notice under Section 79(3)(b), and the first being that there is no pre-decisional notice that is provided. There is no reasoned order. In cases where the entire account was taken down, no specific URL or content which was found to be objectionable was highlighted. Instead, the entire account was taken down. Further, another significant issue is that which state authority, like whether the central government or a state government's department or law enforcement agency has ordered the blocking, is just not provided. So it's impossible through just that notice to find out who is the authority which has ordered the blocking. There's also no accessible grievance redressal mechanism. So there is a huge opacity about how to go about unblocking this accounts or how to seek any sort of redressal at all. So what we did was that we filed four separate writ petitions before the Delhi High Court, where we challenged the account blocking and sought a restoration of the blocking of the blocked account, along with a copy of the blocking order, so as to find out who has ordered the blocking. And I'm happy to say that we got favorable orders in all cases. And so we got orders where we received the blocking order from the respective intermediary, and then we were also granted liberty to move the relevant jurisdictional high court, depending on which state or central government authority has ordered that blocking. Now there are several issues that crop up when there's this tedious process to even just get a simple blocking order, because it effectively leads to two separate rounds of litigation. First, we need to approach the High Court just to find out who has ordered the blocking, and then once we have that information, then only can we approach the relevant jurisdictional High Court challenging that blocking order. This adds to a huge burden on the litigants themselves and also arguably on the judicial system as well. So this is the stage that we're currently at. We have got copies of the blocking orders, and then we have now moved the relevant jurisdictional high court, and the matter is proceeding in those relevant high courts now. So this is the way we have assisted four people whose accounts are blocked under Section 79(3)(b). Yeah, that's it from my end. I will now hand it over to my colleague Indu, who will discuss content moderation and other matters that we have done over the past 3 months. Thank you.
Okay, hi. I will be taking you through some of the other cases that we've done and then also the content moderation work, litigation around content moderation that we've done. As is clear, content moderation is usually done by the platforms, unlike what Avanti and Naman described, which are state-led blocking of access to particular information or accounts. Content moderation is done by the platforms themselves, and it can either affect particular content, and in certain cases, it can affect entire accounts. So the platforms usually decide when accounts can be permanently banned for violation of their content moderation policies. And there's been a sudden increase in the number of permanently banned accounts in India. And what has then been the process is that because the platform usually says there's no further recourse after a permanent ban, the, we've been using the Information Technology Act's process of first going to the grievance officer. But if you look at the form for the grievance officer, you realize none of these you know uh, options address a permanent ban related query. But anyway, you will have to generate a complaint reference number so that you can approach the statutory authority of the Grievance Appellate Committee. Presently, MIT has appointed 3 grievance appellate committees. So if you take the reference number that you've gotten from the grievance officer of the specific platform and then say that the grievance has not been addressed by the platform, the grievance appellate committee has about 30 days, but it's only an endeavor clause. So they will endeavor to consider your appeal within 30 days to sort of resolve your appeal. But because the GAC itself has been riddled with so many appeals in the past 2 months, they haven't been complying with this timeline. And in certain cases, it's been 2 months and no appeals have been disposed of. So in one such case, we assisted an advocate who was facing a 60-day delay before one of the grievance appellate committees. We approached the Delhi High Court with a prayer, which was simply that seeking expeditious disposal of the appeal. And the High Court directed for the first time in one such case that the GAC should dispose of the appeal within 30 days. So that person's account has since been restored. And then there are other cases that are not related to content moderation or blocking that we've been doing, which I wanted to highlight. Um, Two of them are defamation cases. One is a case where um, a huge business entity has filed a defamation case against persons for posting an online review of their dishwasher online. And while this suit has, run for more than 5 to 6 years, and the clients, uh, the two persons are very stressed by the judicial process itself. We are helping them resolve the matter through a settlement. Hopefully, it will be completed over the course of next 2 weeks. And then the second defamation case is where we are representing the Kashmiriyat. It's a press publication based in Jammu and Kashmir, which is now non-operational. They are facing a defamation proceeding initiated by Mr. Arun Kumar Mehta, who was the ex-chief secretary of Jammu and Kashmir. And he is seeking a broad takedown of various news articles and posts from various as he was not happy to delete press publications for any of the defendants. He was not happy to delete the defendants who are deleting the press publications in these proceedings, even if we were to carry his version of the story. We realized that we have to contest this fully. Uh, the third set of proceedings that I want to highlight is actually a personality rights case filed by Vivek Oberoi. We are appearing on behalf of Indian Hippie, an entity that sells old vintage posters in Mumbai. As you'd know, celebrities are rushing to courts to seek broad and vague injunctions against a whole host of images or names that are names of uh, that are used in any form. We believe that without a high threshold of misappropriation for commercial gain, such personality rights should not be recognized simply based on bare assertions. It not only violates the right to profession of persons like Indian hippie who are operating a business selling old vintage posters, but it also affects derivative creative works, which are a component of the right to freedom of speech and expression. So we've also moved a deletion application in this case, saying that we've taken down the links, but were it to fail, we have to anyway, enter defense, and so we've filed pleadings as defendants as well. Lastly, as you would all know, on 29 May 2026, the Delhi High Court upheld the recognition of the right to be forgotten and directed de-indexing of several judgments and news articles, and also directed disabling of name-based searchability of judgments in Indian Qanun. We are assisting Indian Qanun with filing appeals against this judgment, so it would be a very important set of proceedings before a division bench of the Delhi High Court, and I hope you stay tuned for updates in this case. Thank you.
Thank you so much, Indu. Thank you so much, Naman, Avanti, for all the work which you are doing. For the people who are watching this, and usually these calls don't have a lot of people, and people trust us to do the best, and they really do stand behind the work which IFF does. A lot of this work is done actually by the people here, and they work on really hard problems. They work against odds, and sometimes the work which they do also involves a sense of mission. So I'm truly grateful that the organization is lucky to have such a litigation team which looks at these problems from the point of solutions, both for clients but also the direction of the law, right? What can be a good space in which, given the challenges which are confronting our country, the democratic process and the constitutional rights right now, what role can the courts still play? Because there's a big question which people keep asking, is that should we even approach the courts? And this is where a lot of my colleagues are able to, with belief, mission, rather than fatalism and pessimism, still act. And another very viable area which this does still remain is policy. And policy is, our belief is, should be public policy, which means that it should reflect both what Indians are actually wanting technology to serve them as, rather than being a complex document which is only debated by experts. So making policy much more accessible for the people and making them stakeholders in this process, but also representing their true interests, which are quite often not here or not heard in expert committees or in the evidence which is placed before government. And here, a lot of the work is being done by Janvi Anam, who's my colleague here. Janvi has been putting in a lot of work to make sure that the public consultations specifically, which are being done by different ministries and are done transparently. There is adequate information explanation which is provided to all of you, and also there's an ability which you have in participating it, because quite often the most effective thing is if the policy itself reflects a constitutional understanding rather than us being forced to go to court. So I'll turn this over to my colleague Janvi, who's the sole staffer right now in the policy vertical, has an incredible amount of burden and is being able to perform on it in a very exemplary manner. Due to the support which we have received, we hope to further make hirings in the policy vertical and build it out through the course of this year. But for now, it's just Janvi, and I'll turn it over to her.
Thank you very much for your kind words. Hello everyone, and thank you all for joining us today. I am Janvi Anam and I work as a policy counsel at the Internet Freedom Foundation. A significant part of our work this quarter involved closely tracking policy and regulatory developments as they emerged. What this allowed us to do was to respond at different stages, first beginning with our initial statements or first reads, which were followed by more detailed explainers, which were either coupled with RTI applications that were seeking greater transparency or representations that set out our concerns and recommendations, or sometimes even both. To give you a sense of how this approach worked in practice, at the beginning of this quarter, next slide please. At the beginning of this quarter, on the 30th of March, the Ministry of Electronics and Information Technology had published proposed amendments to the IT rules seeking public consultation. First, IFF highlighted that the consultation timeline was not in accordance with the PLCP, which is the Pre-Legislative Consultation Policy of 2014, on the proposed amendments to the information technology rules. Post this, it was um, it was posted that the timeline for consultation had been increased, which is why we further then, which was also coupled with then when we published an explainer examining the amendments and their potential implications. We also created a short template along with it, which was a templatized email that individuals could use to communicate their own concerns directly to the ministry as well. And very surprisingly, more than 6,000 people, or between 6,000 to 7,000 people, used the link to participate in the consultation process, which was extremely encouraging. We further also raised our concerns with regards to government's app banning practices. Concerningly, with the recent Telegram judgment, the Delhi High Court has now blessed this approach by reading apps within the ambit of the definition of information that has been given under the IT Act. Um, this was the Following this, an RTI request was also um, filed with the ministry in order to get a response on the number of app bans that took place within the last 5 years or so. For that, we did not get a particular answer or a segregated answer that these are the number of app bans or this is the particular account that was blocked. Rather, the answer that we got was that the answer indicated that in the years 2023 and 2024, a number of URLs were blocked, and this showcased that in 2023 and 2024, the number of URLs that were blocked doubled as compared to 2022 or 2021 through under 69 A of the IT Act. So this was what we figured through our RTI application. Further, in this quarter, we also raised concerns regarding Delhi Police's expansive data demands from X Corporation, especially when a particular FIR number, which has been also given in one of our blogs, which is 135/2026, wherein user data was sought within the FIR itself. Uh, which After which we had published a statement, and we highlighted that such broad demands were disproportionate and could have a chilling effect on privacy and freedom of speech. Um, Further, in the next slide, we also analyzed proposed rules such as the Telangana hate speech and hate crimes prevention bills, as well as Odisha hate speech and hate crimes prevention bills. We sent our representation expressing our concern and flagged that they reproduce what Karnataka's earlier bill was. Neither of the proposed bills have any safeguards, and that Odisha's reading of the precedent is extremely selective. So, these were some of the few representations and RTIs that we filed throughout the year. We are also part of the steering committee of the Global Encryption Coalition. In our engagement with them, we joined the coalition in issuing a statement raising concerns about Instagram's rollback of certain encryption features. We followed this with a detailed analysis explaining why the rollback is concerning and why is it important for users to understand that it impacts their privacy and security. um, yeah, through this, I wanted to illustrate give a broad sense of how the policy vertical has worked over the past quarter by tracking developments, explaining the implications to the public, seeking information from authorities, and intervening directly through either strategic litigation, which is taken over by the litigation team, or through representations wherever necessary. All the work conducted by the policy vertical could not have had been possible uh, without the support of the team from friends from litigation and comms team. And overall, in terms of numbers, we submitted more than 10 to 20 representations and filed more than 10 to 15 RTI applications as well. Each of these interventions were aimed at ensuring greater transparency, accountability, and protection of digital rights. Thank you very much. Now I will pass it over to our director Apar, who will walk you through our work to further contextualize the areas of our engagement. Thank you.
Thank you so much, Janvi. Thank you for all your work. We are grateful that you've been pulling in and you've been able to, also look at these complex policy documents, which brings me to the civic literacy vertical. So, if we can have the next slide, and this will be introducing some of the work which we have been doing, in which you have seen a great amount of visibility for IFF. And one thing which is uh, before we go towards that, the last slide on the policy vertical may also be important. And some of this is not captured on our website, is that we've been coordinating and supporting both the Cockroach Janta Party. When its handle was taken down, we supported them and we had conversations. And we also collaborated with them a little bit in our civic literacy vertical. And also the two cybersecurity researchers, Nisarga Dirgari and Sarthak, I also provided advice to them how to make responsible disclosures, and we will keep supporting them. and it concerned the larger CBSA's on-screen marking portal, the issues around that, the cybersecurity vulnerabilities, which were also at one point in time part of our Plug the Breach portal, in which we were looking towards documenting data leaks. So, yeah, as I was saying, the last part is the civic literacy vertical. And here you may have seen a lot of our work has become more visible. We have collaborated with more people. We're trying different formats. And I'll pass it on to my colleagues there, Vikram, Advik, Ranjini, and we have a new addition there as well. So to you, Vikram.
Good evening, friends. My name is Vikram, and I manage the civic literacy vertical at IFF. And over the last 3 months, our public engagement has grown significantly. I think on Instagram, we got around 40 million engagement in the last 3 months and around 13,000 new followers. And at the same time, on Twitter, our work reached around 7 to 8 lakh people, reflecting a growing audience engaging with digital rights issues. So we also produced audiovisual content covering several digital rights issues, including digital campaigns against the IT amendment rules, as my colleague Janvi said. And the strategy was instrumental in our recent growth, relying heavily on translating dense policy changes into urgent, accessible short form videos formats. Uh, at the same time, our comics get lots of engagement on our social media. So our colleague Advik will tell you more about it.
Thank you so much, Vikram. Hi, everyone. I am Advik, and I work as a comic artist for IFF. I primarily use comics as a way to translate complex policy and rights based issues into formats that seem urgent and hard to ignore. A lot of these themes we engage at IFF, such as digital rights, surveillance, freedom of expression, are often a little dense. And I feel like comics help kind of bridge that gap. They allow us to, distill complex ideas into clear visual narratives without oversimplifying the core issue. At the same time, they create an emotional entry point, whether through humor or irony, which makes the content more memorable. Across all formats, our objective remains consistent. We aim to make important issues more accessible, engaging, and harder to ignore. Uh, Now, I will pass on to Vikram. Thank you so much.
Thank you, Advik. And the recent update is to expand our reach and strengthen the civic literacy efforts. We also collaborated with several social media creators who helped us to make complex digital issues more accessible to people. Uh, uh, for instance, we worked with Srishti Khanna and Prashant Pundir to explain Instagram's changes on the end-to-end encryption process, and Meghnath to unpack the proposed IT rules. We also launched a new content vertical with creator Sukhda Chaudhary, who will review books on technology and public policy in collaboration with IFF. And these collaborations reinforced an important lesson for us. When complex policy issues are communicated through trusted and relatable voices, I think they resonate with much wider audience and encourage more meaningful public engagement. Uh, that's it. I'll just call Apar to tell you about our finances.
Thank you so much, Vikram. So, as you just saw that, a lot of our civic literacy work reaches a lot of audiences, helps structure conversations on complex issues of digital rights, but it does a little much more than that. According to me, it also sets the frame of conversation for mainstream media publications as well as popular conversation on the basis and the strength of the both the litigation and the policy work. And here, what's important to also understand is that we quite often issue statements. These are detailed analysis based responses which are posted first on Twitter, which are quite often carried in the newspapers or even quote tweeted very widely by leading decision makers. So, for instance, when Telegram was banned in India, the statement which was made by IFF was quote tweeted by Pavel Durov, who's the founder of Telegram. And there are many, many instances like that. For instance, us fact checking Mr. Nishikant Dubey, who made a statement regarding levying a tax on X Corp or Twitter because it was not engaging in fact checking, etc., which we also explained why the parallel and the reliance on the Australian law was incorrect. But the civic literacy article is where we are trying to build also competence for video literacy, trying to build in terms of next steps over the next quarter, regular output of not only short video content, but longer form explanatory analysis, which can be posted on YouTube. And we've heard that feedback also that why don't you do podcasts? Why don't you invite guests? So we're also kicking around that idea. We want to do it well. We're a very small team. We're a very under-resourced team in which each person is doing 4 to 5 functions. They are, trying to hack their way through the entire week. So we just want to do it well and also want to make sure we have the capacity of doing it sustainably. And this is where resources come in. This is where the conversation about the money comes in. So all of these people are basically being supported by you. Monthly expenses usually average between 8 lakhs to 9 lakh rupees. So all of this work which you're seeing only costs about 8 to 9 lakh rupees, which is equivalent sometimes to the salary of a director level person in a non-profit abroad, or is equivalent to engineer salary, a senior engineer salary in India. So the entire org, Internet Freedom Foundation, does the entire work of digital rights quite often, which is done by us, is supported on the basis of individual donations from people who are ordinary Indians. Because we can't take foreign money, we can't also take money because just of the political environment by Indian corporations who are also reluctant sometimes to give us their CSR funds, also the way it's structured. And we are no longer supported by any philanthropies. So the figures which are there are in front of you. If you see in April, May, June, the one-time donations are there, which were modest, and the memberships also which were there were modest. But we also had some org side donations which were there. Fixed deposit matured as well. And if you look at it, this was made possible because we have an annual membership drive in which we wanted to reach a sustainable level of having 800 members. We could reach about 560, 580. And that was also because a lot of online creators, stand-up comics, political influencers use their online followings to help us. And I've made a thank you video on that also, just giving them a shout out. So a real community came together to support us in this time of need. And if we can have the next slide. So you can see this breakup a little much more clearly now. So our current position is that we have about 47 lakh rupees in the bank. Okay. And this is the income breakup where the untimed donations, member contributions, and the institutional donations are there, and the expenses are also there. So the contractor payments over this quarter, if you notice, are basically quarter by quarter the amount of money we are paying. Salaries are for people who are usually employed, not as lawyers, and the stipend is there for an intern. And rent is thankfully right now consensually not being charged from us. But yeah, I'll come to that a little later. That's a temporary situation because we are also trying to reduce costs all the time. So thank you so much. And we are here on questions. And a lot of the questions deal with org side stuff rather than program stuff. And some of them are comments. Uh, some people have said this is really complex. Some people have given us uh, suggestions on a small 20 minutes video, more around current intent and civic literacy. Yes, we can do that. What's our approach? And let me just take that back to the team, and possibly we can explain that, or we can create packages for that as well. We can also try scripting this, going into it into a little much more detail rather than having a live call. But that takes away a little bit from the interactivity, where we can show you specific examples. And yeah, and just in terms of the question that is it possible to open up donation option without giving PAN details? Well, if we accept any money without PAN details, there are few risks which emerge immediately. Number one, a lot of people who have NRI accounts will be also, they may have a PAN, they may not have a PAN, but the PAN helps us validate to a certain extent that a person is an Indian citizen, right? So we want to validate because we can only accept money from Indian sources. And that PAN is then queried by the income tax website to generate a 10B certificate, which is required from non-profit organizations. And if we don't do it, it constitutes a anonymous donation. So that creates another risk for us. Anonymous donations are also taxed. And then we have to also make sure that the anonymous donation, on that we have to pay a tax if we utilize it to 30%. So just due to the risk matrix, the regulations, we do query PANs. We always have kept it safe, and we have only used it for regulatory purposes of generating the 10BE certificates. And you can find more literature on this online of how non-profits are doing this. And given the kind of work which we do also, we have to take these steps for our safety, that IFF as an organization is able to do it. And just in terms of donors feeling comfortable, over a given year, about 5,000 to 6,000 people donate to IFF. They disclose their PANs to us. So there's actual strength in numbers. And these are sums which range very, there's a diverse set of ranges to it. So it can be from about 10 rupees and goes all the way up sometimes to 5 lakh rupees in a single donation. So I would say that I would encourage people, please do donate to us, and don't feel any kind of hesitation in using your PAN. And the ones who do feel that hesitation, we also understand you, that you may have real privacy risks, and which you may be considering in that choice. So respect that as well. And we'll try to make this a little much more simple next time, a little much more well rehearsed. We'll possibly do that. Okay. And finally, Hitesh, you can reach out to us. While we do not offer within IFF pro bono legal aid for commercial entities who suffer takedowns. That's not part of our mission. We are happy to look at the issue, so you can reach out to us separately. So that brings the call to this quarter to an end. We're looking forward to the next quarter and continuing our work. There's also Privacy Supreme, which will be coming up, and we'll let you know that how this annual event which IFF organizes will be conducted. Okay, so thank you so much, guys, and thank you so much for everyone who joined, and thank you for everyone who will be watching this on YouTube. Please feel free to send us feedback. Please feel free to contact us on our social media, and if you do not notice, email is often the best way to send us your thoughts, comments, requests for help, and possibly support us. Thank you so much. Bye.